Welcome back to Law Dogs. I'm Jeff Henley, your host, and with me as always is Annabelle. Now, today we're going to continue our discussion of excessive force. Now, remember from previous discussions, excessive force covers two areas of the law. It covers torts and it covers constitutional laws. Some people say excessive force is in essence a constitutional tort because you can commit it by having a battery at common law, or more commonly, what we see in most instances, it's a Fourth Amendment violation that is prosecuted through Section 1983 of the United States Code. To make an excessive force claim, though, you have to prove certain elements. To prove excessive force, a plaintiff must 1. Show an injury, 2. which resulted from the use of force that was clearly excessive to the need, and 3. the excessiveness of which was objectively unreasonable. So what are we talking about, Law Dogs? Well, before we get to those last elements, let's talk about the first. You have to prove an injury that resulted from the force.
We'll take note of this.
In previous cases, the standard used to be that the injury could not be, quote, de minimis. That is, it couldn't be light or virtually non-existent. That requirement is not in force anymore, but I will tell you this much. If you're asserting that, oh, those handcuffs hurt my wrists, forget about it. If you're talking about saying that the handcuffs, for example, were too tight, you better have permanent nerve damage or some serious abrasions or some other kind of visible signs of injury on your wrist. In other words, a simple pain here and there is not going to satisfy the injury requirement under a Fourth Amendment claim. Now, concerning where the injury came from is a big part of any excessive force claim. So, for example, there's a bar fight and people beat on each other. Then the police come, and in order to break up the fight, they do some beating of their own. Well, in that process, can you determine which injury was caused by the people you were having a fight with or whether it came from the police? In short, you better be able to prove that it came from the police and not the other individuals. More important, you had better be able to show that the force that resulted in the injury was excessive force. Because when you're talking about excessive force claims, you're talking about excessive force. What do I mean by that? A major assumption of the underlying rule is we have to empower the police with force. They have to be able to apply force in order to get people to do things they otherwise wouldn't do, like put their hands behind their back and have handcuffs placed upon them. So as a result, when we're talking about the injuries that someone suffers, it has to be the result, not merely of any force, but of excessive force. Now, when we're talking about excessive force, we are talking about an objective standard, what a reasonable officer would have done under those particular circumstances. We are not talking about a subjective standard, that is, whether the officer had good faith or bad intentions at the time that he was using the force. We are talking about an objective standard, what a reasonable officer would have done or needed to do under the circumstances as they were taking place right then and there. Under the leading case of Graham versus Connor, the United States Supreme Court makes it very clear that it doesn't want judges playing Monday morning quarterback with respect to decisions that cops make out in the field. The Supreme Court makes it very clear that judges are not supposed to sit in their chambers and, with the advantage of 20/20 hindsight, second-guess officers on the street. In the words of the Supreme Court, not every push or shove even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. Officers often have to operate under tense, uncertain, and rapidly evolving circumstances. That's a lot to unpack, Law Dogs, isn't it? You can tell already that the United States Supreme Court is saying, look, these cops, they're out in the field. They're doing all kinds of stuff in circumstances that are rapidly evolving, tense, and uncertain. And we're not going to have trial judges second-guessing them. And it's the kind of thing that the court says, we're going to look at only the things that the officer knew at the time that the force was applied. When it's more than apparent that the force that was used at that time, with what he knew and what he should have known and could have known reasonably, then and only then are we going to make a decision about what is excessive. Excessive force is a controversial subject. It's often one that we see so much more now because of the greater number of means of recording it. We have cell phones, we have body cam footage, dash cam footage, and lots of different kinds of surveillance cameras that can provide us the same footage as well. In coming episodes, we're going to talk in greater detail about other elements of excessive force claims. Until then, if you have any questions, you email us here at Law Dogs. I'm Jeff Henley, and with me as always has been Annabelle. We'll see you soon. Until then, you stay out of trouble or the Law Dogs will get you.